According to the Environmental Protection Act of 2000, highways, resorts, ports, and just about any development or activity that can have significant impact on the environment may require an Environmental Impact Assessment, EIA for short. The project must also follow the rules set out in the Environmental Impact Assessment Amendment Regulations of 2007. An EIA is an analytical process that systematically examines the possible environmental consequences of the implementation of projects, programs, or policies. It is used in three key ways. 1. As a planning tool to promote sound environmental development practices. 2. To examine both the environmental benefits and drawbacks of project design. And 3. To ensure that mitigation measures are outlined to address the environmental consequences during project development. So, how does the EIA process work? When a developer submits a project proposal to the Department of the Environment, it is reviewed according to the law and with input from relevant government agencies, NGOs, and the public to determine whether or not an EIA or Limited Level Environmental Study, LLES, is required. If neither an EIA nor LLES is required, then an Environmental Compliance Plan, ECP, is developed and signed between the DOE and the developer. The ECP is a legally binding document which outlines conditions and guidelines under which the project must be developed. Simply put, it states what the developer can and cannot do while providing the DOE with authority to monitor compliance during project development. Thereafter, environmental clearance is granted for the project. However, if an EIA or LLES is required, the process is much longer. If an EIA is required, the developer is informed. Once the developer agrees to move forward with the EIA, a terms of reference is developed. The document identifies major environmental areas that may be impacted by the proposed development. These include, but are not limited to, the impact on water quality, quantity, and accessibility, the effects on the populations and habitats of key species, and the impacts associated with generation of solid, hazardous, liquid, or sewage waste, energy generation, transportation, and socioeconomic factors, to name a few. When the EIA is completed, it is submitted to the DOE for initial review. The completed document should include the following: an executive summary, a policy, legal, and administrative framework, and project description. It must provide details on the physical environment, the significant environmental impacts, the direct and indirect impacts, and the environmental consequences. Finally, it must provide project alternatives, mitigation, and monitoring plans. When the EIA report is finalized, the developer must also submit a copy of a public notice to be published in 2 widely circulated newspapers to invite public participation in the process. This is also promoted on the DOE's Facebook page. The public notice must include information specific to the project, such as name of the applicant, location of the project, and nature of the proposal. It must also state that an EIA was submitted and where a copy of the EIA can be found, along with the time and period for which it will be accessible. And finally, a deadline and address for filing comments. The public notice must be published for 2 consecutive weeks prior to the date of the scheduled public consultation. Public consultations provide a 2-way flow of information. Project proponents and developers and the EIA team officially present the document and findings to the public, and on the other hand, the public, especially local communities and other interested parties, are able to ask questions or make comments related to the EIA or other concerns directly related to the proposed development or activity. Comments are recorded and forwarded along with copies of the EIA to the National Environmental Appraisal Committee, also known as NEAC. This committee, which is chaired by the Chief Executive Officer in the Ministry of Sustainable Development, Climate Change and Disaster Risk Management, comprises the Chief Environmental Officer, the CEO in the Ministry of Trade, the Financial Secretary, the Commissioner of Lands, the Chief Forest Officer, the Chief Engineer, the Chief Meteorologist, the Director of Health Services, the Director of Geology and Petroleum, the Fisheries Administrator, a representative of a tertiary level institution, 2 representatives of the NGO community or private sector, a person qualified and trained in human development or social services, and a person qualified and trained in coastal zone or marine resources management. Once the review is complete, the NEAC can make one of 4 recommendations: that the EIA is inadequate and requires further investigation, that further public consultation is needed, that the development should not proceed, or that the development may proceed, however, subject to conditions. If the EIA is recommended and approved, then an ECP must be developed. Once input is provided by the NEAC and other stakeholders, the ECP is signed by the DOE and the developer. While the EIA process is thorough and lengthy, it ensures that development takes a proactive approach in properly evaluating the potential impacts on human health and the natural and cultural environment. Furthermore, it considers alternatives to both project design and mitigation measures. In a nutshell, the EIA process ensures that balance is maintained between development, the environment, and society.